Hey there, future lawyers. Welcome to another episode of Substantive Spotlight, where we're diving into contract law. I'm Lee Burgess, and today we're talking about how contracts come to life, grow up, and sometimes, well, break their promises. Think of it as a soap opera, but with more paperwork and fewer evil twins. You know what's fascinating about contracts? They're everywhere. Every time you click I agree on your phone updates, grab your morning coffee, or order those late-night impulse purchases online, you're swimming in contract law. Today, we're going to break down the key concepts we've covered in our Listen and Learn series, and trust me, understanding these will make you the life of any law school party, if that's a thing. So let's start at the beginning. Every contract has a story, and it usually begins with an offer. Not the romantic kind. We're talking about the I'll sell you this for that kind. In contract law, we're always looking for that magical meeting of the minds, where both parties agree on what they're getting into. It's like a dance. Really, one party leads with an offer, the other responds with acceptance, and somewhere in there, we need consideration. That's the legal term for what's in it for me. Now, here's where things get spicy. Not everyone's word is as clear as they think it is. Enter our friend, the Parol evidence rule. Think of it as our bouncer at club contract, deciding what evidence gets in and what stays out. As we've covered in our Listen and Learn episodes, if you've got a fully integrated contract, that's fancy talk for everything's in writing and we mean it, you can't just show up later with some conversation from last Tuesday and say, but wait, there's more. But what if something in the contract isn't clear? Well, that's when our bouncer might let in some evidence to help explain what those terms mean. It's like having a translator for contract speak. Just remember, this rule is all about prior or contemporaneous statements. If you make changes after the contract, that's a whole different story. Now, let's talk about performance, the doing what you promised part of contracts. Sometimes it's crystal clear. You either painted the house or you didn't. But often it's more complicated than that. Maybe you painted the house, but used eggshell white instead of pearl white. Does that matter? This is where we get into the territory of substantial performance versus material breach. Think of it this way. Substantial performance is like getting a 90% on your exam. Sure, it's not perfect, but it's pretty darn good. A material breach, on the other hand, is like showing up to take the wrong exam entirely. One gets you a passing grade with maybe some point deductions, and the other, well, let's just say you might need to retake the class. But here's a plot twist. Sometimes people don't even wait to breach the contract. They do it in advance. We call this anticipatory repudiation, which is basically someone saying, yeah, about that thing I promised to do, not going to happen. It's like canceling a date before you even get stood up. When this happens, the other party has options. They can treat the contract as broken and sue right away. They can wait to see if the other party changes their mind. They can try to convince the other party to perform. They can even find someone else to do what was promised. And let's not forget about impossibility and impracticability, the I really can't do it defenses. These are like the emergency exits of contract law. But don't get too excited. Courts don't hand these out like candy. Just because something becomes more difficult or expensive doesn't mean you're off the hook. As we learned in our Listen and Learn episodes, these defenses are more for those acts of God situation, not I didn't realize this would be so hard scenarios. Here's a quick attack plan for analyzing contract formation and performance issues on an exam. 1. Start with formation basics. Valid offer and acceptance, proper consideration, any formation defenses. 2. Check what evidence we can use. Is the contract fully or partially integrated? Are there any exceptions to the Parol evidence rule? Any subsequent modifications? 3. Look at performance. What exactly was promised? Was it actually performed? And if not, how significant was the breach? 4. If there's a breach, classify it. Material or minor breach, anticipatory repudiation, or any valid defenses like impossibility. Now, if you're thinking, wow, that's a lot to master, don't worry. We've got you covered with our Listen and Learn series. Let me give you a roadmap for diving deeper into these topics. Start with formation and interpretation. Our episode on Listen and Learn Parole Evidence breaks down everything you need to know about what evidence courts will consider when interpreting contracts. Think of it as your guide to contract interpretation drama. Then, when you're ready to tackle performance issues, check out Listen and Learn Material Breach versus Minor Breach. This episode is crucial for understanding the difference between, oops, I messed up a little, and wow, I completely dropped the ball. We walk through real bar exam questions to show you exactly how these issues pop up on test day. Got a party who's breaking promises before they're even due? Our Listen and Learn Anticipatory Repudiation episode has you covered. And for those, but I couldn't help it defenses, dive into our episode on Listen and Learn Impossibility, Impracticability, and Frustration of Purpose. Trust me, these defenses are trickier than they sound. Pro tip, listen to these episodes in order. Start with formation, then move to performance issues. It's like building a house. You need the foundation before you can put up the walls. Each episode includes practice questions and detailed analysis to help you master these concepts for any exam. And trust me, these topics show up all the time. Remember, contract law is all about expectations and fairness. Courts want to enforce agreements, but they also want to make sure nobody's taking advantage of the situation. It's like being a referee in a game where the rules are written by the players. Stay tuned for part 2, where we'll dive into the exciting world of what happens after a breach, remedies. Because let's face it, sometimes I'm sorry just doesn't cut it in contract law. We'll also talk about all the different types of damages and who can actually enforce these contracts. Third-party rights, anyone? Until next time, this is Lee Burgess signing off from Substantive Spotlight on Contracts, where promises matter and performance is everything. Please like and subscribe so you don't miss future content.